Okay, let's dive right into this fascinating explainer on South African contract law. We're going to explore exactly who actually has the legal power to bind themselves to an agreement. I mean, it sounds simple enough, right? Two people agree on something, they sign a piece of paper, and boom, you've got a contract. But looking at the source material, it turns out the law has a very strict lens on who genuinely has the mental and legal competence to make those signatures stick. If you've ever wondered how legally binding your everyday agreements really are, well, you're in exactly the right place. Here's our roadmap for today. We'll follow a pretty clear arc, starting with the baseline basics of legal capacity before moving into the exceptions. So we'll hit age and contractual limits, marriage and property regimes, mental states and intoxication, and finally, we'll wrap up with prodigals and insolvency. All right, Section 1, Basics of Legal Capacity. Let's make sure we have our terms straight before we start looking at all the exceptions. So, the absolute most crucial point here is distinguishing between simply existing as a legal subject who has rights versus actually having the legal capacity to sign on the dotted line and form a valid contract. Think about it like this. A newborn baby has legal capacity. They can inherit a house, they have fundamental human rights, but that baby obviously can't go down to a dealership and buy a car. The actual ability to participate in legal dealings, to perform what the law calls juristic acts, is known as the capacity to act. And as we're going to see, the law views your capacity to act through the lens of whether or not you can form a will and appreciate the real-world consequences of your actions. Moving on to Section 2, Age and Contractual Limits, let's see how your age fundamentally dictates this power to act. Looking at the three major age bands in South African law, it's worth noting that the Children's Act actually lowered the age of majority from the traditional 21 down to 18. So, kids under 7, they have absolutely zero capacity to act. They literally cannot even legally accept a gift. Then, between 7 and 18, you enter this gray zone of limited capacity. At this stage, a young person obviously has a mind of their own, but the law basically assumes they lack mature judgment. So they need a guardian's assistance to make any contract enforceable. But once you hit 18, assuming there are no other limiting factors, you've got full contractual freedom. But here's where it gets really fascinating. The law carves out some highly specific statutory exceptions where minors suddenly get full capacity without needing their parents. It essentially recognizes that in certain modern situations, young people just need autonomy. For example, at just 12 years old, a child can consent to their own medical treatment or an HIV test as long as they have sufficient maturity to understand the risks. At 16, they can walk right into a bank, open an account, manage their own money, or, believe it or not, even draft a legally valid will. Let's ground this theory in a real-world scenario. Say an unassisted minor sells their bicycle to an adult for 400 Rand without their guardian's permission. What happens? Well, the adult has zero contractual remedy. They can't force the minor to hand over the bike. If they want their money back, their only legal lifeline is to sue based on something called unjustified enrichment, which brings us to a really interesting legal crossroads. If you think you can just easily cancel a contract your teenager signed, you might want to think again. The legal outcome depends entirely on exactly how that 400 Rand was spent. If the kid took the adult's money and just blew it all on arcade games and candy, just squandered it recklessly, the adult gets absolutely nothing back. The minor is no longer enriched, so the law protects them. Now, if they bought a luxury item, like a fancy radio, they just have to surrender that item. But if they bought basic necessities like food or winter coats, things that parents were legally obligated to buy anyway, the parents are actually the ones enriched because they saved money. In that specific case, the guardian has to pay the adult back. And keep this number in mind, R100,000. Because if a minor owns immovable property worth more than 100,000 Rand, selling it requires way more than just a parent's sign-off. You need the master of the high court's consent and potentially even approval from an actual high court judge. The law is fiercely protective of a minor's major assets, making sure parents can't just casually sell off, say, a family farm that their kid inherited. All right, Section 3, Marriage and Property Regimes. Let's see how tying the knot can dramatically alter your contractual baseline under the Matrimonial Property Act of 1984. It turns out your chosen marriage regime strictly dictates whether you need your spouse's permission to sign a contract. If you marry in community of property, which happens to be the default in South Africa, your two separate estates literally become one joint estate. Because you share all profits and losses equally, the law says you absolutely must get your spouse's written consent before making huge financial moves, like selling a house or standing as surety for someone else's debt. On the flip side, marrying out of community of property means you remain completely financially independent. You've got full capacity to act on your own, except when it comes to covering the costs of everyday household necessities. As you can see from the act itself, if your spouse goes out and buys a bunch of clothes on a store account while you're married in community of property, the joint estate becomes entirely liable. Remember, it's a community of both profit and loss. You can't just throw your hands up and say, hey, I didn't buy those shoes. The joint estate is on the hook for it. Okay, moving right along to Section 4, mental states and intoxication. How exactly do temporary or permanent mental states influence a person's capacity to form a valid legal will? The absolute crucial point here is the concept of a lucid moment. Even if a court has formally declared someone mentally deficient and appointed a curator to manage their affairs, if that person signs a contract during a lucid moment of normality, that contract is 100% binding. The law doesn't just glance at a medical file, it looks at the exact factual moment the pen hit the paper. Did they understand what they were doing at that exact second? If yes, the deal stands. Now, having an official certification does shift the burden of proof. Usually, the law presumes you're normal, but if you're certified as mentally deficient, the presumption flips, and whoever wants to enforce the contract actually has to prove you had a lucid moment. And when it comes to intoxication, well, there is a very strict presumption of normality. If you try to claim you were too drunk to be bound by a contract, the heavy burden of proof falls entirely on you. You can't just have a couple of beers, sign a bad deal, and back out of it the next morning with a hangover. You literally have to prove that the alcohol or drugs completely stripped you of the ability to understand the nature and consequences of your actions. And let me tell you, that is a very high bar to clear. Finally, Section 5, prodigals and insolvency. Let's explore how going completely bankrupt or just recklessly squandering your own money impacts your right to participate in legal dealings. There's a massive, fascinating distinction here. A prodigal is someone who throws their money away so recklessly that the court basically has to step in and treat them illegally like a child with limited capacity. They lose almost all independent capacity to act. An insolvent person, on the other hand, someone going through formal bankruptcy, only loses capacity regarding the specific assets trapped inside their sequestrated estate. An insolvent person can still sign an employment contract, go about their daily life, and make a living. They just lose control over the assets managed by their trustee. Now, it's super important to note that just having prodigal tendencies isn't nearly enough to limit your legal capacity. Just being a big spender or having some bad financial habits doesn't strip away your rights. An interested party actually has to take you to the high court and have you officially legally declared a prodigal before a curator can step in and take over your wallet. So, after unpacking all these fascinating limitations and exceptions, it really leaves you wondering, doesn't it? Based on the strict legal exceptions of age, marriage regimes, and factual mental states, just how legally safe are the everyday agreements you're currently bound to? Whether it's clicking accept on an online terms of service or buying a bicycle from the teenager down the street, the baseline presumption of capacity is constantly shifting based on age, marital status, and even your state of mind at the exact second you agree. Next time you sign your name, remember exactly what kind of legal power you're wielding.